Welcome to another edition of Law and Democracy, a podcast facilitated by the Election Law Program at The Ohio State University, intended to focus attention on various matters of public affairs of the day. Today, I, Steve Huffner, the Deputy Director of Election Law, I'm joined by Ned Foley, the Director of our Election Law Program, from his fellowship at Princeton University, as well as by Terry Enns, my colleague at the Moritz College of Law at Ohio State, and Tony Goggin, a faculty member of Drake University, who's visiting with us here at Ohio State this fall. We are in the thick now of the 2024 presidential election. And Tony, what is it that we'd like to talk about first today?
Steve, our first topic today concerns the case of citizens, not politicians, versus Ohio Ballot Board. This is a case we first discussed last week. The case involves a dispute over how the state ballot board has drafted the language of an Ohio ballot initiative that seeks to end partisan gerrymandering in the state. Our own Ned Foley signed on to an amicus brief in the case. And so, Ned, could you tell us what the argument is that you and your co-signers make in the amicus brief?
Sure, happy to. And first, I should say that credit for this brief goes especially to Nick Stephanopoulos and Ruth Greenwood, both of the Harvard Law School. They invited me to join, and I did. And to be clear, I joined only in my personal capacity, not as a representative of the Ohio State University or Princeton University. But the brief is excellent, not surprising given Nick and Ruth's work in the area of redistricting law as well as election law generally. It's a pretty straightforward proposition. As we discussed, this initiative, which is a group of citizens wanting to improve the way elections work, gathered enough signatures to put on the ballot a proposal that, if adopted, would go in the Ohio Constitution to change the way legislative districts are drawn in the state of Ohio. And for those who know Ohio specifically, it's a state that has particularly had difficulty drawing district lines fairly over the last few decades. And it seems like each decade, the unfairness of the maps gets worse and worse. If we go far in the past in Ohio, we can look at examples where both major political parties have engaged in this bad behavior. Whichever party is the dominant party has been guilty in the past of this. It so happens that the Republican Party is the dominant party in recent years and decades, and they've engaged in this behavior. To try to, cabin some of this history so that we can talk about this and other things, we should note that the citizens of Ohio, in conjunction with the politicians of Ohio, tried to adopt plans in the previous decade to limit this bad behavior. And there were two different initiatives that were put on the ballot. And the goal of those previous initiatives were to have bipartisan boards draw district lines. So politicians, political insiders, if you will, but from both parties would have to sign on to any map for it to be adopted. And the theory was that this wouldn't allow one party to abuse the power and run roughshod over the other party. So it was a nice idea, and those proposals were adopted, but they didn't work in practice. In the latest round of redistricting, there could not be bipartisan agreement on any of these maps, and it just got uglier and uglier and uglier. And the way in which those proposals were written didn't really have a good fallback mechanism if you couldn't get bipartisan agreement. So in the wake of that experiment that went awry, didn't work as planned, the folks who want fair maps said, well, what's the next solution that we should look forward because we want fair maps. So they came up with this idea of a citizens commission, not politicians on the map making board, but ordinary citizens, kind of like a jury of your peers, 15 instead of 12, but the same idea. This is not unique to Ohio. Other states have adopted citizens commissions successfully, including Michigan, a neighbor of Ohio. And I just learned yesterday about a not yet published study that uses statistical analysis to show that these citizen commissions do actually produce the fairest maps of any institutional method. Kind of makes sense because that citizens want fair maps. So they gathered enough signatures, but the ballot board, which is the part of Ohio's government that's responsible for writing the language that voters see when they cast their ballot to explain a proposition like this, basically ripped up what the proponents of the measure did in explaining their goal of fair maps and ending the bad practice of gerrymandering, and just turned it all upside down. And as the opening sentence of the brief says, the brazenness of the distortion of the reality would make even George Orwell blush. It's so crazy what the ballot board did. They did it on a party line vote. The ballot board has 2 members from each party from the state legislature, and then the Secretary of State sits as on the board as well. And so that gave 3 Republicans control over this 5-member board, and they broke 3-2 to create this language. From my perspective, this would be wrong if either party engaged in this conduct. It's just unfortunate that it happened the way it did. So that was the essence of what and just to make real quick, if anybody's obviously can read the brief if they want to, the key point that was made in the brief is scholarship on the topic of redistricting and gerrymandering says that there are different ways to talk about the problem of partisan gerrymandering. You can use an effects test or an intent test. There's different metrics and so forth. But there's universal agreement that a proposal that tries to eliminate partisan bias and lead to districts that are, fairly reflective of the overall electorate in the state can't count as gerrymandering as that term is understood. So the ballot board's effort to taint this proposal as if it engages in gerrymandering instead of stopping gerrymandering wouldn't fit any academically responsible use of the term.
Ned, I thought I'd like to pick up on that, but first I want to just pause and welcome Ann Ralph, who's joined us, another one of our election law at Ohio State faculty members. And welcome, Ann. It's great to have you.
It's great to be here.
One of the additional developments in this particular case since last week is that yesterday there was an announcement, I suppose you could call it, by a small group of opponents of the measure. And one of the things that those opponents were arguing was exactly what you were just talking about, Ned. They were arguing that this new proposal, were it to be adopted by the voters of Ohio, would mean that this new redistricting commission would have to engage in gerrymandering. They said something almost exactly to that effect as one of their criticisms of the measure. And so I do think it's really important to acknowledge, as you just did, Ned, that all realistic definitions of gerrymandering are capturing a different disease of the redistricting process that would not, in fact, be infecting the new process if it were adopted in Ohio.
I find it big picture interesting how the goal in the past, way back times, used to be defeat this thing at the ballot, have more people vote against it than for it. Whereas now our direct democracy attempts in Ohio, there's so much playing around before it gets to the ballot. You know, we've just sort of changed the location of where the fights happen all the way, you know, several cycles ago when it was paying off the signature gatherers with a $2,000 and a ticket to anywhere in the US so that not enough signatures would be gathered, or competing petitions so that not in anyhow, we're fighting the fights at a different stage now that I think is it's unfortunate if you like democracy and want people to vote what they, you know, this could be voted down without playing games if you make a good argument rather than, you know, sort of tainting the process before the vote.
It does come down in a really fundamental sense to something I know that we've talked about before as a team, which is what amounts to fair play in the arena of election law, election mechanics. And, you know, it's one thing for candidates themselves to try to sway voters by exaggerating their views or distorting their opponent's views. But it's another thing entirely to take the process and begin to stretch and pull at the process in a way that prevents voters from participating in a fair choice of options.
And I think it's interesting, Steve, to think about how traditionally, at least in modern times, we've thought about the ballot as something that's neutral. But just exactly as Terry said, it has now become another battlefield in partisan polarization. And it's striking to me that the term, one of the points that Ned and his co-authors make in the brief is that gerrymandering is a pejorative term. It's not a neutral term. And so it's striking that a pejorative term is allowed on a ballot when you can make it, as Terry said, you can make an argument against a pro-independent redistricting commission position without having to engage in pejoratives. So it's disappointing to see election officials accept a pejorative term on a ballot that's intended to just provide neutral information to the voter.
Yeah, and just to be clear, the particular proposal wouldn't be my own preferred way to handle the issue of redistricting or districting or gerrymandering. I think from a purely ivory tower perspective, you know, if I were in charge, which I'm obviously not, I would tackle the problem of fair maps in a little bit different way than this proposal. But as Terry said, let the voters decide whether they want this or not. And it doesn't have to be a perfect proposal or the best proposal to be better than the existing system. And given the record of the regrettable good attempt but bad result of the last round of citizen initiative, my own judgment is this would be an improvement on the status quo, and therefore give this one a chance, because we're not getting fair maps under the current situation.
And these types of measures, when they're put before the voters, almost always are going to require some sort of explanation, summary for the voters to be able to have in front of them when they are voting, that it's a little too much to actually give the voters only the legal language that would become part of the Ohio Constitution in the event of this particular measure, or that might become a new statutory law in the event of a particular statutory initiative. That legal language is always available. Every voter is able to see the precise language, but it is sensible to then want to summarize it in what would be a more layperson's language. And that summary then needs to be a fair summary. And that is what the ballot board is tasked with doing. And, the issue that we're raising is that the ballot board is not always fulfilling that obligation in the ideal way. Now, ballot boards in many states are structured in similar ways. And the underlying problem, as we talked about last week, is when partisanship creeps in, or more than creeps in, floods in to some of these mechanics. So you have the Ohio Ballot Board splitting 3-2, and there are ways of running elections that don't depend on the two major political parties fighting it out with respect to these types of mechanics. Now, we also talked last week about an analogous problem occurring in Utah involving a different measure on the ballot this fall for Utah voters to consider that would amend the Utah Constitution, where the summary language for it has also been crafted in such a way that it is also now the subject of a court challenge on the basis that it is distorting the process in an unconstitutional way. But it's interesting to note that Utah used to have a ballot board that would be responsible for doing the work of preparing that summary. And just recently, the ballot board was scrapped in Utah, and the responsibility for crafting the language was given to the president of the Utah State Senate and the speaker of the Utah House of Representatives alone. Now, if they're of opposite parties, then there might be some give and take, and maybe they come to a fair agreement, but they're aligned right now, and that's how the language that's now being challenged in court in Utah was developed.
I can
Oh,
go ahead. No, Ann, go ahead.
I say Terry made the point that, citizens look to the ballot, voters look to the ballot for the language to be neutral and informative. And there are, I don't know if this was mentioned before I joined, but there are studies that show that the more, the less information voters have, the more they rely on the ballot language, and the more influential that ballot language is in helping them decide how to vote. So it's interesting that the battle is that we've been talking about has moved on to ballot language from maybe the contest of op-eds and advertisements, et cetera. If we're seeing less of those because the language is slanted in one way or another, I think that would be a really interesting study to measure, how much public information has been shared by proponents or opponents versus the controversy over the ballot language.
Yeah, and that's a really good point, and it actually feeds in nicely to the larger point, or more historical point, that I was going to make. I've been doing some research on what our founders wanted democracy to look like, and the concern that they had that politicians would be self-interested, and how could the ordinary citizens police bad behavior by self-interested politicians. And one of the insights that our founders, like Madison and Jefferson and John Adams, and all of them, they knew that they had to rely on a sufficiently educated citizenry to protect their own commitment to self-government, because politicians can get away with more self-interested bad behavior if the citizens themselves aren't vigilant or don't understand the way in which the politicians are trying to abuse the sovereignty of the citizens themselves. So there's this constant tension between the citizens wanting ultimate power, but needing to delegate power to the government temporarily on their behalf, and then the risk that the government will abuse that. But that can kind of only work over time if the citizens are able to hold the government to account. And there's a lot more complexity to that, but the thing that worries me, and the fact that this is happening in 2 states, and it's also happening at a time where we're getting all these challenges to American democracy in general, not just on ballot initiatives and redistricting and so forth. I worry that the citizens aren't sufficiently attentive to their own capacity to protect self-government for themselves. And I worry whether it's because of our fragmented media environment or the decline of civics education and K through 12 learning in high school, that we've lost our muscle memory as citizens for what we have to do as a way of our own self-protection.
Yeah, and Ned, on the fragmentation point, I think it's really interesting that it's so hard now for campaigns in general to reach the electorate because people aren't watching Cheers or Seinfeld collectively live on a Thursday night. They're streaming, they're watching when they want. They can fast forward through commercials or pay for a service that doesn't provide it. And so all advertisers, political advertisers, car dealership advertisers, they're all competing for this shrinking share of the advertising platform that's still reaching a live audience. So local news and sports, which then means when you're the government trying to communicate, it's so hard. Or even an advocacy group, because the price for 30 seconds and cost of that kind of advertisement just keeps going up because there's so many people competing for it. So it's very troubling to think about just the most basic facets of political communication in the country right now are challenged by all kinds of technological developments that have benefits, but wow, we really see here one of the downsides of them.
It's sobering to think about how our digital age, despite some real capacity or potential for making it easier for citizens, for voters to have some broader understanding of background facts about things, in fact, is having the opposite effect. And, you know, we're talking about one discrete dimension of that in terms of how voters understand what a popular initiative would actually do. But that's just one piece of the broader question of how do citizens have accurate information. And it's a real challenge for us today.
Do you mind, can I ask all of you just for an unscientific sort of gut check of what your instinct is on the following question? If our fellow citizens were asked, what's more important, that there be fair play in elections and government, even if that risks that your team loses, or, you know, don't worry about fair play as long as you can win. What do you think the breakdown of honest public sentiment would be on that question in America today? And is that different from years past?
I'm an optimist, so I'm going to take the position that I think more voters would value the idea of fair play over a particular position winning. But I can see, you know, I can see how there would be significant doubts about that outcome. But I still think we value the idea of fair play and hope that our, you know, any person hopes that the ideas that they support could win in the marketplace of ideas fairly. I'm going to take that optimistic position while leaving room for other folks to weigh in.
Well, I think that you're right, Anne, that a large majority of people, if put that question, would opt for the fair play kind of response. At the same time, I'm going to say that many people's judgment of what fair play is biased by the outcomes it produces, and that itself creates a problem.
And I would go one step further, that I think there is a small but mighty group that doesn't believe that there could be fair play. And that's the group that I fear most, because if you give up on the idea that it, you know, that, I mean, I trust the machines, I trust the people, I trust the counters, I trust all those pieces. But if you don't trust those pieces and don't think it can ever be fair, then your person should just win by fiat. And that sentiment really scares me.
Building on Anne's optimism, one thing I would say is that if Anne's right that most people want fair play, even if Steve, there's sometimes, you know, are not quite seen it the way they should, at least that reservoir of goodwill is something to work on and build on. Yeah. It means that education can work and better improvement. whereas if people don't care about fair play, then I don't know how you remedy the situation. I mean, in other words, if social solidarity is broken down that to the point where, you know, we're at each other's throats, to the point that we don't really care about treating each other fairly, getting better educated about what fair play consists of wouldn't make a difference. I mean, the
I
only
think
way,
that's really important, and I would wholeheartedly agree with Anne's optimism in that respect, and with your desire then, Ned, that we capitalize on that. I think there is a huge role for all of us to be playing in stressing this shared commitment to fair play and in wanting to try and unpack what that really amounts to and how do we enhance it, how do we preserve it, how do we extend it. That's really what we should be all about.
can I ask another question sort of along the same lines? Insofar as any of us observe politicians engaging in behavior that we think contradicts fair play, do we think of these politicians as wanting to be fair, but themselves misguided in the way Steve was describing that it could happen to citizens? Or do we think that these politicians know that they're not engaged in fair play, kind of like what Terry was describing of a subset of citizens, but these politicians believe they can get away with unfair play because they're not being adequately policed by citizens one way or another? In other words, do politicians have good intentions? They're just misguided, or are we looking at politicians who actually know that what they're doing isn't kosher, so to speak, but they want to do it anyway, just for the sake of power?
Steve's heard this phrase a million times when we teach together, and that is, I always encourage my students with the phrase that you should presume positive intent, that people don't go into politics because it's fun and easy. It's really, really hard to run for office, and it's really hard to be, you know, in the arena, making the decisions, being responsible for them and all that. So I think presuming positive intent on the part of all the players until you have really clear evidence of something else is the way to go. So for the most part, I think people actually believe what they're saying and believe what they're running on, and you know, believe that. I think the people who think that the election system is not being run fairly actually believe it's not being run fairly and think that there's holes in the system or in the process. So until I have facts or something really clear, I just presume that people are not intentionally misleading or mischaracterizing what's going on.
I think your question, Ned, raises, and I mean, there's a piece of it I want to pull out, which is, you mentioned sort of what's keeping politicians honest, are they in this situation? And so I think it makes you think about some different levers that we might think about, you know, at work and in informing whether politicians feel like they can make claims that are accurate, or they're bound to make accurate claims, or whether they can sort of make claims that are that they don't actually believe in, or that they know not to be true. And so those kinds of things that we depend on in having a good information environment include like clear information being shared with the public, fully functioning press, you know, educated citizenry, all those different things that we're thinking about, I think inform the environment where politicians can choose to make claims, and whether they think they can say things that are true or just say things that they think will be, you know, get their ends.
And just to be clear, I tell my students a version of what Terry says you and Steve tell yours, especially with respect to judges. I say always presume, you know, sincere intent on the part of these opinions that you read. You might disagree with them, or they might be mistaken, but presume good faith. And I'd like to do that with respect to elected politicians for the most part as well. And I 100% agree, Terry, that historically up until recent years, I thought most politicians did go into public service with a real commitment of public service, and it's a hard job and it's really difficult, and you get pulled in different directions. But one thing that's made me more troubled in recent years, both specifically in Ohio and nationally, is you can look at individual politicians who acted a certain way, in a way that correspond to fair play and good faith, and when these same individuals do a kind of a 180 and go to the dark side, so to speak, then I have a harder time attributing a good motive, because it's harder to think that that same individual is now duped in a way that they weren't before. Instead, it seems, again, we can never look inside anybody's head, but if certain office holders start behaving in really manipulative ways where they were straight shooters before, so to speak, that change of character suggests that indeed a change of character has occurred, and that the psychological disposition of that individual is no longer trying to do good, just maybe confused about what doing good means, but instead they become corrupted, to use again the framers' understanding of political corruption, is when a politician decides not to serve the public interest as best as they can understand it, but is designed to serve either self-interest or some partisan interest or so forth. And I do
So
think,
here's a hard question that yet extends our abstract discussion even farther away from the question of the ballot board language where we started. But, one way you might think about trying to identify that kind of change in values among a politician is to identify, we call it flip-flopping, right? Identify when a politician has in fact departed from some previous position. And I've always found the charge that a politician has become a flip-flopper or is a flip-flopper to be a really superficial and worthless exercise, because on the one hand, we really expect our politicians to be doing the wishes of their constituents. And if what has happened is the constituents' preferences have changed, then maybe we ought to expect that the politicians themselves are now articulating a different position. So the fact that they're behaving differently in and of itself, to me, is not a fair way of assessing the integrity or the good faith of the politicians. And so when you think about that with respect to this really sort of fundamental question about what fair play in politics is, and you have politicians who at time A were behaving in one way and now at time B are behaving in a very different way, is it because they were once principled and are now not? Or is it because they have in both instances been simply functioning as the intermediary or the agent of their constituents, and it's the public itself who has now gone over to the dark side, as you put it?
And there's a third option in there too, which is that the politician, as the representative in a representative system of democracy, has gained new information that makes a different perspective or a different stance the appropriate one. It's not even because their constituents say, but because as the person who's supposed to be acting on behalf, they're getting different kinds of information. So I think it's kind of weather vane versus new information or change of constituent attitudes.
yeah, I think those are good points, and maybe I wasn't sufficiently clear. I don't think there's anything inherently pernicious in a politician changing policy positions,
I
especially.
wasn't describing that view. I wasn't saying that's what you were saying. I was just saying that at some point you may have to look at changed positions and think about what the impetus was.
I guess what's disturbed me, and without getting into name calling and specifics, I do think the office of Secretary of State is an office that is entrusted with the responsibility of supervising the conduct of elections, and therefore, even if it is itself an elected position, there's an inherent obligation to administer the electoral process fairly, for the sake of all the voters and all the candidates and all the participants in the system. And I think all of us can imagine or recognize when an individual has held that position and has been exemplary in that respect, for year after year, decision after decision, and then suddenly something happens, and that same human being starts to make decisions after decisions that can't be characterized in that same way, and seems at every turn now designed to favor one particular party and their candidates, and just has a track record of behavior in a second period of time just antithetical to the track record in the first period. That feels to me different than, policy changes for whatever reason, whether constituents have decided they want different policies or because there's new information. That seems like a change in attitude about how to go about exercising the public trust that you've been given in your office.
And I think this generation of politicians is experiencing more sustained and intense constituent pressure than any generation of politicians since at least Watergate. And one of the great challenges for elected officials on all ends of the political spectrum today, it seems to me, is related to what we were just talking about before, how difficult it is to get a message out to the voters in this competitive media market and fragmented media market. Whereas in contrast, it's easier than ever for disgruntled members of the political parties to communicate their frustration to their elected officials, whether it be through Twitter, through email, and elected officials have less privacy in so many ways because so much information is out there about them. And we're certainly seeing this in the judiciary as well as in our legislative and executive branches. So I think that's part of this as well. It's a certain type of partisan discipline being imposed on our elected officials by our two big polarized constituencies.
Great point.
And maybe that's playing out in the ballot boards.
Could be. Well,
Can I just say, can we hit the pause button on our recording or cut this, what I'm about?
Wow, that's been just a really fascinating exchange of some pretty important fundamental ideas. And I think I'm happy to call it a day with that, except that I know we've got a trivia question, both last week's to provide an answer to and a new one for next week. So what have you got, Tony?
that's right, Steve. If viewers remember and listeners, our trivia question last week was, who was the first Supreme Court justice, current or former, to receive a vote in the Electoral College? And now we'll have a little drum roll, or at least I'll make reference to a drum roll while you ponder that question. And the answer is, in 1796, Chief Justice Oliver Ellsworth received an electoral vote for president, as did former Chief Justice and at the time, current New York Governor John Jay, and a third justice, Associate Justice James Iredell, received electoral votes. So 3 Federalist Supreme Court justices received electoral votes in 1796. As it happened, the vice presidency that year went to Thomas Jefferson, and the winner of the presidential race was John Adams. The fact that so many candidates received electoral votes reflected, of course, the fact that the 12th Amendment, which established separate ballot for president and vice president, was not yet on the books. That would be almost 7 or 8 years later before that would be adopted. I might add, in that election, 2 electors even voted for retiring President George Washington. So that was certainly a memorable election, the 1796 election. Now, our trivia question for next week is based on a topic we discussed last week, which was Robert Kennedy's challenge in getting off the ballot in the battleground states after suspending his 2024 presidential campaign. This week's trivia question concerns his late father, Senator Robert Kennedy of New York. Bobby Kennedy was elected to the United States Senate in 1964, but his 1964 Senate campaign ran into a major election law issue that proved deeply embarrassing to Kennedy's campaign and was constantly brought up by his Republican opponent, but it did not prevent Kennedy's election. The question is, what was the election law issue that plagued Bobby Kennedy throughout his 1964 Senate campaign? Stay tuned next week for the answer.
Thanks, Tony. That's great. We will look forward to that, and we hope that all of our listeners will be able to join us then. So until our next time, thank you all for being with us today.